Human Tissue Amendment Bill 2020. And before I get into some of the substance of the bill and some of my concerns, I would like to make it very clear that I support our organ donation program. Just a few days ago on November 22nd was Donate Life Thank You Day, a day to thank organ donors and their families for the lives that they've saved. The Federal Minister for Regional Health, Regional Communications and Local Government, the Honourable Mark Coulton, released a statement on the day, and I will just briefly quote from that statement. He said, in 2019, 1,683 lives were transformed by the generosity of 548 deceased and 239 living organ donors and their families that said yes to organ donation. A further 12,000 Australians benefit from eye and tissue donation. End quote. This is wonderful. For people who choose to donate, this is their last gift to the world, and I'm sure it brings some relief to their family members that in some way their memory is preserved through bringing life or better health to another person. The bill before the House today seeks to clarify in law an important aspect of this organ donor program. Previous reforms to another act had created an ambiguity around the consent for ante-mortem procedures related to organ donation. This bill is important in providing the legal clarity for the medical profession to be able to respect the wishes of people who wish to donate organs and tissues upon their death. While it is somewhat discouraging that late amendments were introduced in the other place, nevertheless, most of the bill is good. It ensures a clear line of consent for these procedures. These ante-mortem procedures might include things such as blood tests, other scans, injecting anticoagulants or putting a person onto a ventilator to ensure the preservation of their organs for donation. I suspect that it would be likely that most of the people who have registered their consent to be an organ donor would also consent to these procedures. In fact, one of my staff who has signed up as an organ donor had assumed that they had. But after reviewing all of the relevant websites and the organ donor registration form itself, these procedures aren't mentioned. This is a problem, as informed consent is a critical component of medical ethics, and it's also a critical component to remain compatible with the Victorian Charter of Human Rights and Responsibilities. There are times when this is appropriate to be circumvented, such as the immediate need to preserve a person's life, but we shouldn't play fast and loose with ideas around consent. This brings me to my concern with the bill, which I will be seeking to address through an amendment. And could I ask that the amendment be circulated now, please?
Thank you. Pause for a minute. Amendment will be circulated. Thank you. Thank you, Mr. Limbrick. You can continue.
Thank you, President. The new Section 24E states, and I quote, a designated officer for a hospital may give an authority under Section 24B where the designated officer A, after making such inquiries as are reasonable in the circumstances, is unable to ascertain the existence or whereabouts of the medical treatment decision maker of the person, and B, this is the important part, has no reason to believe that the person had expressed an objection to the carrying out of ante-mortem procedures in respect of that person. This means that if the person responsible for making the medical decisions on behalf of the individual cannot be found, then it can just be assumed that they are okay with it. And even worse, if the individual hasn't expressed any prior objection, then it is taken that they are okay with it also. In other words, if they are silent, they consent. It would not be acceptable to apply this logic to other realms, such as sexual consent. In fact, we demand the opposite approach. Clear and direct consent is essential. Anything less than that is considered an offence. Some may assume that because they have registered to be an organ donor, it is granted that they, or the medical treatment decision maker, are okay with the process. And indeed, we have heard that view here a number of times today. The procedure may be minor, perhaps even considered trivial, and the individual may be okay with it, but that's besides the point. No matter how little or how large a procedure it may be, the individual or their appointed representative is ultimately responsible for the decision. I understand that in some circumstances the individual may appoint a medical decision maker, and this is a serious responsibility, and I suspect a heavy weight on the shoulders of the appointed person. However, this section 24E brings up another possible scenario. Perhaps this sibling has been entrusted with the decisions of the patient's body. How would they feel to find out after they couldn't be contacted that their brother or sister has had a procedure without their consent or even their knowledge? There is no place for medical professionals to be making assumptions about the desires of patients, and this bill exactly and explicitly provides for this. I'd like to thank Ms Patton for drawing my attention to the Scrutiny of Acts and Regulations Committee report, which also highlighted concerns along these lines and sought responses from the Health Minister, and I thank the committee for their work on this bill. But the SARC report, if I quote from the SARC report, and I quote, "The committee notes that medical treatment, ante-mortem procedures and organ donation may be distinct procedures and that consent to one procedure may not imply consent to the other procedures. For example, a person's willingness to let a particular individual make decisions about what procedures should or should not be taken in response to various medical conditions does not necessarily imply a willingness to let that individual make decisions that facilitate post-death organ donations. Likewise, a person's communication of consent to post-death organ donation does not necessarily imply a willingness to be injected with anticoagulants or have life support maintained purely for that purpose." End quote. This is good work from the committee, and it gets to the heart of the matter and my concerns. While the response from the Minister adequately addressed some of the concerns of the SARC committee and led to some corrections, it didn't adequately ease my concern about 24E. Now, I understand that this is a very narrow case. We are considering people who have registered or otherwise expressed their intent to donate organs who are right at the point of the end of their life. People may consider this trivial, but it's these narrow edge cases that provide an ability to clarify our approach to morality and medical ethics. I do not accept the Minister's response that, and I quote, "There are no less restrictive means available to ensure this important public purpose of facilitating viable organ and tissue donation is achieved." End quote. No less restrictive. We've heard this before. We've seen this flippant dismissal of any consideration of less restrictive measures on human rights of Victorians all throughout this year. It's at the heart of many criticisms of this government's pandemic response, and I suggest they try harder. We have very well established state and federal protocols and policies around informed consent to medical treatment. The solution here seems relatively straightforward to me and in line with the National Safety and Quality Health Services Standards. Point 1.18 and particularly point 1.182 highlight that improvements in the documentation of informed consent help protect patient rights. We should update our National Organ Donor Registry to make it clear that these ante-mortem procedures may be necessary to facilitate successful organ donation and give people who register the ability to clearly consent to both donation and these procedures. It would make the clause completely redundant. I've written to Minister Coulton, who is responsible for the federal scheme, suggesting this change, but in the meantime, the Liberal Democrats cannot support the legislation in its current form, not with this ambiguity around the issue of consent. I urge other members to support my amendment and ensure that our principles are clearly reflected in our laws. I further urge the government to work with their federal counterparts to update our registry and ensure that there is a clear chain of informed consent to all procedures involved in organ donation. Thank you. Being a libertarian is sometimes described as like being the only sober person in the car and no one will let you drive. The government is driving us into the dark.